So I think the Texas law at issue in this case, which prohibited withdrawing or withholding life support from a pregnant patient, is unconstitutional for potentially two different reasons. The first being that the Supreme Court has determined in a case called Cruzan that individuals have a constitutional right to have life-sustaining treatment withdrawn or to refuse life-sustaining treatment. And that's a constitutional right that's grounded in the constitutional right to privacy. So in this case, Marlise Munoz had a constitutional right to not be hooked up to life support. Of course, Marlise was declared dead before she was hooked up to life support, so she wasn't in any position to exercise this right on her own behalf. But the Supreme Court in Cruzan did find that a surrogate could exercise this right on behalf of an individual under certain circumstances. And in this case, there was clear and convincing evidence that Marlise would not have wanted to be hooked up to life support in a situation like this. So, pursuant to Cruzan, she had a constitutional right that could be exercised on behalf of her surrogates to refuse life-saving medical treatments here. And then, of course, we have to also consider the right to abortion, which was established in Roe v. Wade and refined under Casey v. Planned Parenthood. And that case found that a woman has the right to an abortion that is unburdened, that cannot be burdened by the state up to the point of viability. So here we had a 14-week-old fetus, which is about 10 weeks prior to viability. So Marlise Munoz did have a right to exercise, or did have a right to abortion in this case. Of course, Marlise, again, was brain dead at the point that she was hooked up to life support. So she was in no state to exercise this right. So that brings up the interesting question of whether her right to abortion can be exercised on the behalf of a surrogate. To my knowledge, there has never been a case that's addressed this issue, but I do think that there is a colorable argument to be made that Marlise's right to abortion was implicated and violated in this case. So I think the bioethical principles that apply most in this case are autonomy, non-maleficence, and beneficence. And I think the one that looms largest is autonomy. So in this case, Marlise Munoz had made clear throughout her lifetime that she would not want to be hooked up to life support in a circumstance similar to the one she found herself in. Of course, at the time she was hooked up, she was brain dead, so she was not an autonomous agent. But her family attempted to vindicate her wishes on her behalf, to exercise her right to autonomy on her behalf. And that's something that is protected under the right of autonomy. When it comes to the principle of non-maleficence, I think we have to think about the family. Obviously, at the point that Marlise was hooked up to life support, she was no longer a being, no longer a person. So we could argue that she was not suffering any harm at that point. But certainly in watching the documentary, it's apparent that her family suffered greatly from Marlise being hooked up to life support. Not only were they grieving for the fact that Marlise's wishes were not abided by, but they then had to watch the body of their loved one be used to incubate this fetus as the body kind of degraded, which is, I think, a traumatic experience. And then I think we also have to think about the fetus in this case and apply beneficence and non-beneficence. Some would argue that it would be to the benefit of the fetus to allow it to develop and be brought to term. But in this case, first of all, there was evidence that the fetus had suffered anoxic brain injury. So it's debatable if the fetus was brought to term, whether the fetus would be would it be viable, if not severely disabled. So I think the question of whether the Texas law is morally permissible, or whether it's morally permissible to to go against an individual's wishes not to be hooked up to life support in order to gestate a fetus is certainly a tough question, but I feel that we have to leave it to the family to decide. And that's in part because it's debatable, or it's up to kind of personal belief whether there is in fact a life there at that point. And going back to Roe v. Wade, the court decided that, and Casey, the courts decided that the state might have an interest in protecting the potential life of a fetus, but that interest doesn't become compelling enough to override the rights of a woman until the point of viability. So I think if we're talking about a pre-viable fetus, as we are in this case, then I don't think it's morally justifiable to override the rights or the preferences of the patient as vindicated or expressed by the surrogates. And in this case, again, the surrogates are the family. So I think notions of personhood don't really honestly apply to this case in any legal sense of the word. So personhood is a very slippery term that can be looked at through a variety of lenses. It can be looked at from the perspective of religion, philosophy, personal belief, law, etc. And definitely in our country, which is a democracy, each of us has the right to define these really big ideas such as personhood, when does life begin, when does life end, to some extent on our own. So some people believe that life begins at conception and therefore there is a person there at the moment that a sperm fertilizes an egg, and that's an absolutely fine belief to hold. But because our Constitution in the form of the First Amendment makes it so that the state can't enforce any one set of religious or personal beliefs on the whole country, that belief can't be enforced via law. So what we do have so then I think when we're talking about this circumstance, a legal circumstance, we have to look at the legal definition of personhood. And in Roe v. Wade, the court actually found that a person under a person under the law with rights doesn't exist until birth. So in this case, if we're looking through a legal lens and looking at the fetus, the fetus was not a person in any legal sense of the word. And then looking at the other party involved, Marlise Munoz, she had been declared brain dead. She was not a legal person at that point either. So we're not really dealing with a case where we're looking at the rights of the fetus versus the rights of Marlise, because we actually have two non-persons at issue here. So really the only persons involved in this scenario were the family. So I do think it is problematic both from an ethical and legal standpoint that 30 other states follow Texas's law. For the reasons I've said, I think that the law is unethical applied to a case such as Marlise's, and also arguably unconstitutional based on the right to refuse or withdraw life-saving medical care and the right to abortion. So I think it'll be interesting to see whether any constitutional challenges to these laws arise in the coming years. And I certainly think it would be a very fascinating and important case for the Supreme Court to eventually take up one day. For people that feel that we always need to err on the side of life, such that what the state did in this case, when the hospital did in this case, would be justifiable, I would say that it really depends on one's definition of life. So going back to this idea that we live in a democracy where each of us is able to a certain extent to ascribe to our own set of personal and religious beliefs, it's again totally justifiable for somebody to take the stance that life begins at fertilization, or some where much before viability. But again, it's not for the state to enforce that viewpoint on everybody else. The judge in Marlise's case did end up deciding that Marlise should be removed from life support and that it would be, that it was lawful to allow the fetus to pass. He came to that decision based on the fact that Marlise didn't fit the definition of pregnant patient, as the law put it, because she was brain dead and therefore no longer a patient. He decided the case purely on those grounds and declined to answer the constitutional challenges to the law. Of course, it would have been, I think, nice to have guidance from a court on the constitutionality of these laws, but I completely understand why he dodged, if you will, that issue. In our legal system, court cases become precedent, which means they become binding on future cases, future similar cases in that jurisdiction. And so judges being aware of the fact that their decisions can have very long-term, long-lasting ramifications, try to be judicious, this is kind of where the word comes from, in how they decide cases. So I completely understand why the judge in this case chose to resolve the issue based on more of a technical reading of the law rather than a constitutional analysis. I think he was properly exercising this notion of judicial economy.